Ben, I want to go to what the Supreme Court did yesterday because they did a couple of things. And I think a lot of people who are conservative are torn on what they did to Title VII because, most people, most normal people they don't have a problem with homosexuality as friends. We work with people. We know people. We like them. It's not a problem. I don't want to get into somebody else's business. But is this another jam down and another intrusion on businesses and religion? Tell me what you think of Title VII and what they did yesterday.
So, to be frank, I've for a long time thought that Title VII probably is unconstitutional in its entirety. The idea that the federal government was ever given the power to invade private businesses and tell them who and who not to employ seems to me incredibly problematic just from a constitutional originalist level.
Yes.
Now, does that mean that I wouldn't have voted for the Civil Rights Act in its entirety? If I'm given the choice between voting for the thing or not voting for the thing, I vote for the thing. But Title VII has always been a real problem because, again, it intrudes into areas that the government ought not intrude. Remember, the big problem with segregation in general was the governments of states that were cramming down segregation, and that there were plenty of places in the United States that were desegregated by private businesses. The Greensboro protests over the lunch counters in Bloomington, North Carolina. Those particular in Greensboro, rather, those protests were private in nature and ended with the desegregation of lunch counters. So the notion that you had to force private businesses to desegregate is not true. What you actually had to do is stop the state from forcing them to segregate in the first place. So put aside the general objection to Title VII. The decision itself is nonsensical on the merits. Samuel Alito's dissent is a masterpiece. It goes for 100 pages, but it tears apart savagely the majority opinion. There's a good case to be made that the reason that Roberts joined this opinion is specifically so he could get Gorsuch to write it. And the reason that he wanted Gorsuch to write it as opposed to Ginsburg, for example, is because if Gorsuch writes it and not Ginsburg, if Ginsburg writes this thing, then religious liberty is in a lot more danger from this specific decision than if Gorsuch writes it. So that really is the question right now. Now, here's my view on a lot of Supreme Court jurisprudence in general. The Supreme Court tries to very often settle questions that are still unsettled, and that really ought not be settled by the Supreme Court. And that is this particular case. This is not within the Supreme Court's purview. And so there are a lot of people today who are celebrating, oh, look, it's a new America. We're all unified now because there's a top-down rule. Here's the thing. America is as politically divided as it has been certainly in my lifetime, and maybe in the lifetime of your listeners, including the 60s. And the idea that you're going to have anybody at the top of the federal government cramming down a one-size-fits-all rule is really a problem. What the founders figured is that in division lies unity so long as you have a diversity of thought and action that is allowed across the country. If you have a unified rule that is crammed down by 51% on 49%, that's when you get into really divisive area. So are you going to keep the country running by allowing people to live their lives? Or are you going to keep the country running by cramming down one rule from the top? This one crams down one rule from the top. And whether you like the rule or you don't like the rule, that's a dangerous thing.
So, I think that's what the French Revolution was all about. And what separates us from the French Revolution is the French Revolution really was about we're going to enforce morality. We're going to enforce what we believe is right. And if you don't like it, guillotine. It doesn't work. The question that I have, though, on this ruling, how does this affect me? And I keep using, let's say let me just use a real life scenario. I think it's Bergdorf Goodman in New York that they hire, quote, models, not salespeople. I can't remember which store it is, but it may be Bergdorf. And this allows them to be able to say when a fat person like me comes in and says, I want to sell clothes here. They can say, I'm sorry, you don't fit the look. And they do it specifically to get around the law so they can make sure that everybody looks a certain way because that's important. I don't want to go in and buy a suit where the guys around me can't even fit into the suit or, they can look at me and I can look at them and they're like, dude, there's nothing here for you to buy, Glenn. You're just too fat to be here. And so it's important that they have a certain image. If I have Bob at the front desk of my business and he comes in and he says, I'm Bobette, and he's wearing a dress, can I fire him because he doesn't fit into the the culture and the image that I'm trying to portray, or does that not matter anymore?
So you'll certainly get a lawsuit. And this has been true in New York for a long time. So New York is actually the wrong example because New York already has anti-discrimination laws, same thing as California, right? 21 of these states already have laws that are very much like what the Supreme Court did yesterday. So in New York, it probably won't affect you, and you probably had to worry about legal liability if you did that in any case. Now, if you do it in Texas,
right,
you have to worry about legal liability, right? That's the real issue here. And by the way, the best example here is actually the case of, if you're talking about things that are a problem, then we should worry less about, the business that has the models and more about your third grade teacher, right? You got a bunch of kids in your school and the teacher comes in one day and says they are the opposite gender and starts teaching your child about transgender ideology. You fired that person. That could very well be a violation of Title VII of the Civil Rights Act now. Now, this is nonsensical. I mean, just on a legal level, it is completely bullcrap. When I say that, I say it advisedly with respect toward Justice Gorsuch, who typically I think is a much better textualist than this. But he admits in the decision this has nothing to do with the Civil Rights Act. He says in the decision that there's no way that the people who wrote the Civil Rights Act meant to encompass in this homosexuality or transgenderism. And the Democrats know this, by the way. Democrats have been trying to pass a separate bill called the Equality Act that would do exactly this without religious exemptions for years. And so the idea that magically you can now read the Equality Act into the Civil Rights Act is insane. I mean, this is something that Alito mocks, and correctly so, because there is nothing textualist about the idea that you can take the word sex and then read into it sexual orientation or transgenderism. In fact, it's the only way. This is the hilarity of it. The only way that you can actually read transgenderism into the Civil Rights Act is to reject the claim of transgender people that they are members of the sex to which they claim membership. So follow me here. The basic idea is that if you fire somebody, Bob comes in one day and he says, I'm Janine and I'm a woman. He has, full beard. He hasn't done any of the treatments, nothing, right? He just comes in and he says, I'm a woman. And you say, okay, well, you're fired, right? You're teaching my third graders. No. And the idea is you have discriminated against him as a man, right? You haven't discriminated against him as a woman. You've discriminated against him as a man, which is a rejection of his claim to be a woman, right? But you discriminated against him as a man. So what's the discrimination exactly, right? You've said you're a man who is doing a thing I don't like, right? But you have been discriminated against on the basis of sex. But sex is biological sex. So you actually haven't been discriminated against as a man. You've been discriminated against presumably as a woman. So none of this makes any sense. The only way you can call it discrimination, again, on the basis of sex, is to say that he is actually a man, which is something that transgender people reject. So you now have the bizarre situation in which it is discriminatory to perhaps say in the workplace, this is where really the rubber hits the road. Let's say that you have a religious school, you have a secular side of the religious school, which all religious schools do. You have a person who comes in and says, I'm transgender now. And you say, well, here at the school, you don't even fire the guy. You say, you know what, you get to work here because of Title VII. And then he's walking around the school and people are saying things like, that's a dude, right? That's not a lady, that's a dude. Is that a discriminatory work environment? It very well may be. And it very well may be a work environment that provides legal liability. So now you get into free speech issues, right? You actually have free speech issues as to what you're allowed to say on this basis, because you're not sexually harassing anybody. You're just saying something that is factually true, but that may very well be sex discrimination under Title VII of the Civil Rights Act. It also provides serious problems for Title IX. So Title VII is now in complete conflict with Title IX. Title IX is designed in order to protect women, right? So Title IX says we're going to protect, for example, women's sports. Well, once you say that you're not allowed to reject transgender people for anything on the basis of their transgenderism, how do you have separate women's sports leagues and how do you fund them? How do you have separate women's bathrooms? How do you have separate women's locker rooms? Now, Gorsuch acknowledges that a lot of these things are undecided. He says, well, we'll save those for the future. Well, great. Sounds fantastic.
Good.
So, I mean, he says, he openly says that, yeah.
I'm sorry to interrupt, but I know I have a short period of time with you, and I want to get to one other question on the Second Amendment. But let me just end this segment with this question. Do you believe the protection for religious exceptions is strong?
No one knows. There's the Religious Freedom Restoration Act, which basically grants you the ability, if you're a religious institution, to protect yourself, but that doesn't necessarily cover secular teachers in your employ. It also doesn't necessarily cover insurance issues. Gorsuch says that he hopes that the religious protections are strong, and he may have those leanings. Now, they've taken up a couple cases on some of these specific issues that are supposed to come down the pike next year, including broadening the ministerial exemption. And so my friend David French, who's a legal analyst with Alliance Defending Freedom, among other groups, he has suggested that what the court may be going for here is so-called fairness for all, which is sort of what they have in Utah, which is very strong workplace protections for transgender and gay people, but also a lot of exemptions for religious people. But who the hell knows? And of course, that could basically change any time, because as soon as the Democrats get into office, if God forbid in 6 months, they just passed the Equality Act. They removed the Religious Freedom Restoration Act, and a lot of those protections are now gone.